Hello, everyone, and welcome to today's presentation. We will get started momentarily.
Okay, let's get started. So, hello, my name is Misha Rashkin, and I would like to welcome you to today's NSGC Consumer Webinar presentation entitled, Is Your Genetic Privacy Protected? Quick introduction about myself. I am a licensed genetic counselor in the state of California. I've worked in clinical and research roles, and now I work at Helix in the Department of Policy and Clinical Affairs. We encourage questions to be asked throughout the presentation. If you have any questions you would like to ask our speaker, please type a question in the chat box. Questions submitted will be read aloud during the question and answer portion of this presentation. By submitting a question, you are consenting to having the information contained in the question read aloud during the presentation. So please do not submit any personal identifiers in your question. Please note, as a courtesy to the presenter, all participant telephone lines have been muted automatically. If you should experience technical difficulties during this presentation, please utilize the question and answer tab to submit any questions or concerns our way. NSGC offers a wide range of educational programming. The information provided in this presentation is not a substitute for medical or professional care, and you should not use the information in place of a visit, call, consultation, or the advice of your physician, genetic counselor, or other healthcare provider. And please note, as it says on the slide, NSGC is not liable or responsible for any advice, course of treatment, diagnosis, or any other information, services, or product you obtain through this presentation. NSGC does not recommend or endorse any specific tests, products, procedures, opinions, or other information that may be provided. Now, it is my pleasure to introduce Anya Prince as our speaker for this webinar. Anya Prince's teaching and research interests explore the ethical, legal, and social implications of genomic testing, with particular focus on genetic discrimination and privacy rights, the intersection of clinical and research ethics, and insurance coverage of genetic technologies and interventions. She has published a variety of articles in legal, bioethics, and medical journals, including the American Journal of Bioethics, the Journal of Law, Medicine, and Ethics, and genetics in medicine. And she has presented and been an invited speaker at conferences across the country. Anya, take it away.
Great. Thank you so much, Misha, for the introduction. I'm thrilled to be here and have had the pleasure of working with Misha with the NSGC Public Policy Committee, and I'm excited to talk to you all about genetic privacy today. So I'm going to cover genetic privacy in 3 different areas: research, criminal investigations, and then other social actors like employers and insurers. But first, we had the NSGC legal disclaimer, but as a lawyer, I wouldn't be a lawyer without disclaimers of my own, so I'll add a few in here. So the first one is, I'm talking about federal law today, but don't forget about state law. It's important to know that there might be additional protections or additional laws out there at your state level. So I'll just talk about some of the broader federal laws today. And in the 30 minutes or so that I'm going to be speaking before question and answers, I'm going to just barely scratch the surface of some of these protections. And so just a reminder that there's lots of nuance and complexity to these. So if you're interested in learning more, make sure that you get advice as needed, because like the NSGC disclaimer said, in addition to this not being any healthcare advice, this isn't legal advice in this presentation as well. And so please, when you do have the question and answer period, ask for broad questions that aren't related to any specific legal advice for you, because I can't give that. So with those under our belt, let's get into the nitty-gritty and fun of genetic privacy. So first, I just want to talk a little bit about different ways somebody might learn about genetic information or get genetic testing done. And of course, there's a whole host of ways that could happen, but 3 big categories are: you could get clinical genetic testing, and the laws that control data policy in that area, one big one would be HIPAA, the the Health Information Portability and Accountability Act, and that regulates what information your medical providers can share. And there also might be state law rules about what could be shared. You could also get testing through direct-to-consumer testing or DTC testing. And so one important place is a starting point to look at for data policies or how information might be shared there are the informed consent and privacy policies of those companies, right? And then if you do genomics research, you can look to informed consent documents and the common rule. I'll talk a bit about the common rule in a second, and state law. And so those are the rules that look at how the groups who do your testing, what requirements there are for their data. But I'm going to talk from the other perspective of how researchers might access information, how criminal investigators might access information, and how employers or insurance might access. And so I just wanted to remind you up front that there are some protections that come through in laws depending on what type of genetic testing you've had. So let's dig in and talk about genetics research. So if you genetic researchers often want people to join studies, but they also do research on biospecimens. And so how do they go about getting somebody's information to do research, right? So there's a couple of different ways. And the big protection in this area is called the common rule. This is an administrative rule that 26 different agencies, including the National Institutes of Health, or NIH, join onto. And it's the law that protects human subjects research. And one of the important pieces for this from the genetics perspective is what the definition of a human subject is. So if a human subject is participating in research, then there's all sorts of protections that there needs to be informed consent, and certain parameters have to be followed in terms of confidentiality and privacy. But de-identified biospecimens are not defined as human subjects. So if there's a biospecimen or in a database, right? So if you get a genetic test and there's some saliva or blood in a database, and then information is removed, right? So any identifiable information is removed, such as name or address or age. So anything that could link you back to that biospecimen, if that's removed, then that biospecimen is no longer considered a human subject. And so research can be done on that using individuals' biospecimens without their consent. And so the protection is that presumably that information, then the results of that research can't be linked back to you because it's de-identified. And so these biospecimens can come from a lot of different areas, right? They could come from another research protocol. So you would read the informed consent of the research study that you're doing to see whether or not they're doing secondary research at all, or it could possibly come from a direct-to-consumer company. If you do direct-to-consumer genetic testing, then they might be able to send de-identified biospecimens that they collect through direct-to-consumer, through their consumers to researchers. So it's important to, and then the common rule also, then if it is human subjects, right? So if you are participating yourself in research, then there's informed consent that you sign to see what happens to your information. Another somewhat new protection that has come out in the research area is the 21st Century Cures Act. The 21st Century Cures Act was passed in December 2016, and it did a lot of things, but in terms of genetic privacy, it requires what's called certificates of confidentiality if there's any government-funded research involving identifiable information, right? So if you're a human subject in a research project and your information is identifiable, then that research project has to get a certificate of confidentiality, and that helps protect the research findings from criminal investigations, and I'll talk about criminal investigations a bit more. It also exempts any identifiable research data from what's called Freedom of Information Act requests, or FOIA requests. And FOIA requests are where people can write into governments to ask for public information. And so somebody couldn't do a FOIA request for identifiable research data. So that 21st Century Cures Act added quite a few levels of protection for research participants, and rules about, and the common rule regulates how researchers use genetic information. So again, I said that this would be the whirlwind tour, so I'll just spend 5 minutes or so on 5 to 10 minutes on each of these topics, and so I'll move on to criminal investigations, which is a fun one that has been in the news quite a bit, right? So you may have heard about, even this morning I read one additional news article about new ways to identify criminals or suspects through DNA and through genealogy. So I'll talk a bit about how criminal investigators can use genetic data. So here's the headlines you may have seen. DNA site helped authorities crack the Golden State Killer case. What the Golden State Killer case means for your genetic privacy. And so the Golden State Killer case was a recent example, but there's been quite a few, both historically and in the past few months since this Golden State Killer case. So I'm going to talk about 3 different pieces of criminal investigations. I'll talk about criminal biobanks, I'll talk about warrants, and then I'll talk about these new genealogical searches. So the first is that criminal investigators have access to criminal biobanks, or the acronym for some of them are called CODIS. And there's both federal criminal biobanks run by the FBI, and there's also state criminal biobanks. And the way that genetic information gets into a criminal biobank is that depending on the state, and you can see some examples. This is back from 2013, these state data, and so they're a little, they may be out of date, but it gives examples that when somebody is arrested either for a felony or a misdemeanor, or sometimes when they're convicted in most states, DNA is collected from those convicted, and then in many states, DNA is collected even for somebody who's arrested, even if they're not convicted. And so that could be for felonies, that could be for misdemeanors, and in some states that's even for juveniles. And so if you're arrested and DNA is taken, then that goes into this criminal biobank, and if there's a future crime that has a DNA sample in it, then the criminal investigators can have access to those biobanks. And in general, you know, the main law in this area is our Constitution. So we have the Fourth Amendment that protects against warrantless searches. So it limits government surveillance without suspicion. So the general principle is that law enforcement has to have some sort of suspicion in order for them to surveil somebody. And so if they want to go into their home or they want to get information, they have to have a warrant. And this can include information about genetics, right? Except data from third parties given voluntarily doesn't necessarily need a warrant. So what this means is that police are starting, if they wanted to get genetic information, they could maybe get a warrant to get that information if they had individual suspicion. But what's happened in the past is they've just contacted companies like Ancestry or 23andMe and said, hey, could you give us this data? And if 23andMe and Ancestry agree voluntarily to give that information, then traditionally that didn't need a warrant. However, there was a Supreme Court case called Carpenter v. U.S. that was decided this past term, and it changes this. This Carpenter v. U.S. case was about cell phone data. And so the principle was if the police go to the cell phone towers and say, can you give us information about a person's location, and that cell phone company did that voluntarily, that traditionally the police didn't need a warrant, but the Supreme Court case Carpenter v. U.S. said, yes, you would need a warrant for that. And so this is a little bit unclear what the implications are for genetic sources, but it could mean that there's, if that principle is applied to genetic sources, then there could be more need for a warrant in terms of police going and asking third parties or companies from giving DNA. And this third party doesn't have to be a company, it can be a family member, and I'll talk about that in a second. And so, you know, the traditional version of criminal investigations was matching the suspect directly to any DNA that was left at the scene of a crime. However, more recently, police have been using what's called familial searches. And under familial searches, they use partial matches to identify family members as suspects. So, an example is California was the first state to approve these familial searches back in 2008 for criminal biobanks. So what would happen is if there was a crime, they would search the database and they might find a partial match. So they wouldn't find the suspect, but they would find somebody related to the suspect. So then they could say, okay, the person that we matched with is a relative of the person we're looking for. And then they could do some more investigation to figure out who it might be. So this happened in a case called the Grim Sleeper that was about another serial killer in California. And he was identified through a criminal biobank familial search. And so that's been happening for quite a while now. And different states allow it under different circumstances, and some narrow it to have to be a cold case or a very severe case, something like a murder, and so they have laws that protect that. But recently, these familial searches have been expanded to use of public genealogy websites, and the one that made this famous is the Golden State Killer. So what police do in this case is they take the DNA from the scene of the crime and they upload it onto a public genealogy website. Now keep in mind this is a different website than the DTC companies that we generally think about, like Ancestry and 23andMe. This is a completely public website that people have put their DNA on in order to maybe find family members. Right? And so the police have used this to then identify partial matches. And this is how they found the Golden State Killer, who was a serial killer in California throughout, I believe, the 70s and 80s. And so on the one hand, this helps to solve grim crimes. On the other, there are questions about what this means for privacy, because if you put your information up on a public website, then all of a sudden you might be implicating family members. And if one of my family members puts their information up on a website, they could be implicating me, even though I didn't consent to have sort of my familial information up there. So it raises a lot of issues. And we'll have to see what the legal implications of these recent cases are. All right, so continuing on our whirlwind, I'll talk next about employers and insurance, right? So there's a lot of different societal actors that may be interested in genetic information, but the big ones that we think about are employers and health insurers, mostly because of the main law in this area, which is the Genetic Information Non-Discrimination Act, which is often shortened to GINA. So GINA was passed in 2008, and it was signed by President Bush. And GINA protects against genetic discrimination in employment and health insurance. So I'll just go over some of the specifics of the law, because I think there's a lot of people who know of it, but don't necessarily know some of the nuances to it. So I'll dig into some of those now. So GINA applies to state and local governments. This is which employers GINA applies to. So in terms of employers, GINA applies to state and local governments. So if you're an employee of a state, then that would apply. It applies to private employers with 15 or more employees. It applies to employment agencies, and it applies to some federal employees, but not all, although there was a previous executive order that protects federal employees from genetic discrimination. And so there's just the federal employees that are not included under GINA still have some protection. And then getting really into nitty-gritty, it does not apply to bona fide private clubs, which most people don't have to worry about, and it also doesn't apply to Indian tribes. So one of the big gaps for many people here are small businesses, right? So for those of us that work for a private employer with 15 or, so if you work for a private employer with 15 or more employees, then GINA applies to you, right? But many people work for small businesses that have fewer than 15 employees. And so what does that mean, right? Does it mean that there's no protection? And usually not, right? So, sorry, that was a double negative. There usually is some protection at the state level. So many state employment discrimination laws often apply to smaller businesses, and quite a few states have laws that include genetic information, and in fact, all have to comply with at least GINA's level, right? So many have, they've changed their state employment discrimination laws to include genetic information, and if that state law applies to fewer than 15, which many do, then there's some protections. State law protections for smaller businesses could be different than GINA, so these other protections that I talk about in terms of privacy wouldn't necessarily apply, but sometimes they have better things, like they have greater penalties if there's some sort of discrimination that happens. GINA also covers health insurers. So in that context, it applies to both group and individual health plans. It applies to Medigap plans. Now, it does not apply to any of the federal health plans like TRICARE, which is a military plan, Veterans Health, or the Federal Employee Health Benefits plans, but all of these are group health plans that already have restrictions in terms of how health insurers can use any medical information. And so if you have any of TRICARE Veterans Health or those, people in those generally do not have to worry about genetic discrimination because they already have protections written in, and so it doesn't matter that GINA doesn't apply to them. But it's important to note that GINA does not apply to other insurances, and this could be any type of insurance, right? It only applies to health insurance, but the common ones that are listed are life, long-term care, or disability insurance. And in general, that's another area where you can look to state law, because there are some protections at the state level that restrict how or when insurers, the life or disability or long-term care insurers, can use genetic information. So that's often a good place to look at state law. And so GINA has really, I think about GINA as having two types of protections. First, there's an anti-discrimination provision or protection, and it prohibits covered employers and insurers from using genetic information to make decisions. So the first thing to note is how they define genetic information. Genetic information is defined quite broadly, so it's quite protective in that way. It covers genetic test results. It covers family medical history. If you participate in genetic research, that's protected. And if you go and see a genetic counselor or you get any genetic education, then that is your protected genetic information. And so employers and health insurers can't use any of this information. But it does not include manifested diseases. And so if you have any symptoms of a genetic condition, even if it has an underlying genetic cause, then that is no longer protected under GINA, although it might be protected under the Americans with Disabilities Act in the case of employment, or the Affordable Care Act in the case of health insurance. And so both employers and health insurers can't use genetic information, and that means they can't, fail to hire, they can't fire in terms of health insurance, they can't deny you insurance or deny coverage or consider it a pre-existing condition. So it's really quite a broad ban. So those are the anti-discrimination protections of GINA, but GINA also has some privacy provisions. And so an interesting part of the law is that GINA prohibits both health insurers and employers from collecting genetic information in the first place. And so both of these groups can't request, require, or purchase genetic information generally. And remember, this includes family history, right? So your employer is not supposed to ask you about family history. However, there are exceptions to this rule for both employers and insurers. So for example, if you're taking FMLA leave, your employer can ask you for documentation of the need to care for a family member, which is family medical history and therefore genetic information. So there are some exceptions to these rules and that I don't have time to go into today, but keep those in mind. If you do have a health insurer and employer that's asking for that information, you can check and see if it falls under one of the exceptions first. But it's also important to note that even if your employer gets genetic information, or even if your health insurer gets genetic information as part of one of these exceptions, the anti-discrimination protections still apply. So they still can't discriminate against you on that basis. So that was my whirlwind of genetic privacy in terms of how genetic information can be used in research, in criminal investigations, and by employers and insurance companies. And we wanted to save plenty of time for questions, because that's really where the fun begins, to get to know what you want to hear. So I think Misha is going to help us out with answering questions that have come in along the way, and I will answer any that you have.
Okay, so I'll start us off with one about the Affordable Care Act. There have been recent efforts to remove the pre-existing condition protections from the ACA. How does that affect Gina?
Great. So the Affordable Care Act was a law that was passed 2 years after the Genetic Information Non-Discrimination Act, so they're separate laws. And as I said, GINA protects against discrimination in health insurance, and under GINA, genetic information cannot be considered a pre-existing condition. Except manifested symptoms can be considered a pre-existing condition under GINA, right? Because it's exempt from that law. Under the Affordable Care Act, that says that no medical information can be considered a pre-existing condition. And so there have been some movements to whittle away some of those pre-existing condition protections. There's a lawsuit going on in Texas, and the current administration has opted not to argue in favor of pre-existing conditions. They're arguing on the side that those are now unconstitutional because of some legal changes and changes to enforcement of the individual mandate. And so depending on what happens in that case, or if any other changes occur, that would get rid of the pre-existing condition protections for manifested conditions, but GINA itself would still stand, right, under that scenario. And so under that scenario, and genetic information, so your family medical history and your genetic test results would be protected, but there unfortunately would be the situation where any manifested conditions would be able to be used like it was prior to the Affordable Care Act. Hopefully those efforts to whittle away those protections will not go anywhere. So there will be robust protections across all of health insurance, but that's something to just keep an eye on. But it's important to know that GINA would still stand depending on how the law was written. But if it's just affecting the Affordable Care Act, then it wouldn't affect the protections of GINA.
Thank you. We have another question here. Let me just read it real quick. So let's say a person wishes to remove their genetic information from a database like Ancestry.com in order to protect their privacy. And there's multiple parts. So one is just, can they do so? The next part is, will it get rid of their genetic footprint and also the families and protect kind of the family's genetic privacy? And then the third part, and I can remind you of these, is their genetic footprint out there forever?
Yeah, so good question. So for the possibility of removing information, that's where looking at what the company's policy is important, right? So for those direct-to-consumer testing companies, in the informed consent document or in their company policies, it would tell a process of whether you could ask to have your information removed, right? One thing about the genetic footprint, right, is I was talking about the de-identified information can continue to be used, right? So the problem is that if the information has already been de-identified and shared with, let's say, researchers, then it's basically impossible to have that information or that data removed because they can no longer link it back to you. So if I, Anya, contact them and say, please take my information, please destroy my biospecimen, and if that's in their company policy and they say they can, it could be that my information is still out there, but it's not directly linked to me. So in that way, privacy is protected in the sense that the researchers don't know who I am, but a genetic footprint is still out there in the sense that my sequence might be in a research protocol, and because it's de-identified, I wouldn't necessarily be able to control that. And then the third question, remind me, Misha?
I think you were kind of answering it. Okay. It's basically kind of the individual's genetic privacy, the family's genetic privacy, and then generally, like, is the genetic footprint out there forever if someone uses this service? So sort of, is deletion really full deletion, or are there limitations to deletion? So I think you went over it.
Yeah, great. Thank you for the question.
I think the next one we have is what protections are available in the case of life or disability or other insurances, which I know you went over somewhat, but maybe you could dive into with a little more nuance. Yeah.
So these really vary across states, as I said. So in some states, there's no additional protections, right? And so therefore no protections because GINA doesn't cover it. But some states ban those insurers from using genetic information, not necessarily all three together. So for example, in Colorado, I believe that group disability insurance policies can't use genetic test results, but it doesn't necessarily cover life. That's off the top of my head. And so different states cover it differently. There's also some common protections that are not a ban on those insurers using it, but some additional requirements. So sometimes they have to get informed consent if they're going to access genetic test results or do genetic testing. Sometimes they have to have what's called actuarial justification. So that just means that they have to have a reason for charging a higher rate or denying insurance. They have to show why the genetic test result that they're taking into account affects the policy in order to use it. So different states have different types of protections. It's also important to note that when you're looking at state law, it's always good to look at what the definition of genetic information is. Because as I mentioned, GINA's definition of genetic information is really broad. It includes not just those genetic test results, but going to see a genetic counselor and participation in research and family medical history. And that might not necessarily be the case in those state laws, right? The state laws might be more narrow in that they only apply to genetic test results or the individual's genetic test results. So when you're thinking about what the state law protections are, if you hear, oh, the state prevents the employers from doing this or prevents a life insurer from doing this, it's good to also just make sure to understand what the definition of genetic information they use is, because in some situations it could be the case where a life insurer can't use genetic test results, but they could still ask about family medical history, for example, something that health insurers under GINA aren't allowed to do.
Great, thank you. And got another one here. So I think we kind of went over that, or you did go over this somewhat, asking about, can the police access different databases? And I think the question here is asking more specifically about Ancestry and 23andMe. So as opposed to the aggregator that you were talking about before, GEDmatch, how about the specific companies themselves? Could the police go to them for criminal investigations?
Yeah, so the interesting thing about the Golden State Killer case is the police were using that public database, so the GEDmatch. And so they could go to other companies and ask for the information, right? It's not publicly available, so they would have to say, hey, Ancestry or hey, 23andMe, would you mind sharing this data with us? Both of those companies, as well as I'm sure other DTC companies, have said publicly that they are not going to comply with any of those government requests. Now, just a note, a request like that is different than a warrant, right? So if the police have a warrant to ask them for information, then, or to subpoena the information, then they may legally have to comply. But those types of companies have said, if they're asking for us to voluntarily give our consumers information, we are not going to do that as part of our policy. In contrast, GED Match, after this happened, made it more clear on their user agreement that this information was public and that it could be used for criminal investigations. And so different companies have reacted in different ways, where the GED Match is saying, sort of, open doors, great, this is great for police to use our services, it's publicly available for this to happen. And then some of the other DTC companies saying, no, we don't, if we can avoid it, we won't have the police come in. So that's something where those companies have been a bit vocal about. And so, if you have used one of those companies, you can look to see what they've said after this about police investigations.
Great, thank you. So those are all the questions that have been submitted so far. I guess maybe we'll take another 15 seconds or so, see if anyone wants to take a last shot at submitting a question, and then if we don't have any, then Anya, if you're okay with it, I guess we can wrap it up.
Great.
Five, four, three, two, one. Okay. So I think that is everything. Thank you so much for the wonderful lecture.
Yeah, thank you for having me. It's my pleasure.
Have a good one. Thanks all for attending.